Good evening, everyone. Good evening. I'm Jeffrey Trezak. I'm the Executive Director here at Dayton Metro Library, and I want to thank you for coming out this evening and welcome you to our Social Justice Speaker Series. I just want to take a bit of time, first of all, to thank some of the people who were involved in making this evening possible. First of all, I want to thank Dr. Carlos Marshall, who is our Director of Equity, Diversity, and Inclusion here at the Dayton Metro Library, and you're going to be hearing from Carlos in just a moment. His vision and passion for service to the community is at the core of this and all of the programming coming out of our EDI department. So thank you, Dr. Marshall. I also want to thank the Charles F. Kettering Foundation for sponsorship of this evening's event, and the Friends of the Dayton Metro Library for their continued and ongoing support of this and all of the programming that we have that's part of our Social Justice Speaker Series. And finally, I want to thank all of you again for joining us this evening, our patrons, our donors, and the community that we serve. Thank you for showing up. Your presence at events such as this validates the work that we're doing and affirms our work. Excuse me, it's full-on allergy season, right? I hope some of you understand. I'm in the process of sort of losing my voice, and I apologize. Your presence at events such as this is what validates and affirms the work that we do here. Without the funding and patronage of folks such as yourselves, we could not bring free and accessible services and resources to all of you, especially to those who need us the most. If you haven't done so, I'd ask you to please consider a gift to Dayton Metro Library, and you can visit our support page, which is at daytonmetrolibrary.org, to find out how you can ensure that your library stays free and accessible to all. Thank you, and I hope you enjoy this evening.
Thank you, Jeffrey, for such a warm and gracious introduction. Good evening, everyone. Good evening. Let's get a little more energy. Good evening, everyone. Good evening. Good evening. Thank you. Welcome to the kickoff of the 2024 Social Justice Speaker Series. My name is Carlos L. Marshall, and I proudly serve as your Equity, Diversity, and Inclusion Director here at the Dayton Metro Library. The Dayton Metro Library Social Justice Speaker Series is an ongoing initiative to bring some of the world's most prominent authors, creatives, scholars, activists, and practitioners to Montgomery County. At the library, cultivating spaces for courageous conversations and intergroup dialogue where everyone is free to belong is core to our values of equity, diversity, and inclusion. The Social Justice Speaker Series places an emphasis on supporting diverse voices, groups, and change agents that come from marginalized backgrounds that have been systematically disenfranchised from the literary canon, publishing industry, cultural and creative scenes, dominant discourses, and beyond. The series aspires to be a springboard for a learning community of social justice warriors, advocates, and allies with an eye towards inclusive excellence. This event was made possible with the generosity of the Friends of the Dayton Metro Library and the Charles F. Kettering Foundation. Now, please help me give a warm welcome to Sharon L. Davies, President and CEO of the Kettering Foundation.
Thank you. Good evening. All right, I want to thank the Executive Director of the Dayton Metropolitan Library, Jeff Cheziak, and also the great team here for allowing me to share a few remarks today. I also want to recognize my sister, who is visiting me in the crowd. There she is over there, Sheila Davies. And it's always a pleasure to be able to speak in front of a family member. It's a true honor to be here tonight and for the Kettering Foundation to help our community sponsor this important event marking the 70th anniversary of Brown versus Board of Education of Topeka, Kansas. It is also an honor to have the opportunity to hear from the daughter of the lead named plaintiff in that case, who will speak to us in a few minutes about the landmark decision within the context of a very personal experience as a member of a family that is connected to the case. I realized this morning as I was thinking about Brown versus Board of Education that I couldn't remember when I first heard the title of that important case. I'm certain it was well before I attended law school, maybe as early as middle school or grade school. I can't say. But that says a lot about the significance of this case to our society. You certainly don't have to have gone to law school, as I did, to know about Brown versus Board of Education. When you hear someone referred to the shorthand title of that case, Brown versus Board of Ed, or even the Brown decision, you know almost immediately that the reference is to the case in which the Supreme Court finally declared unconstitutional laws that banned white and black children from attending public schools together. There are a handful of case names like that in our country that are the names that are familiar to us in that way. The 1966 Miranda case that established Miranda warnings that police are expected to give before interrogating people in custody is one example. Or Roe v. Wade, the 1973 decision which settled, at least for a time, women's reproductive freedom and right to choose an abortion. And more recently, the Dobbs case, I think, has become very quickly a decision like that, reversing Roe v. Wade. So Brown versus Board of Education is in public parlance and is fairly familiar to us. For at least the landmark decision that was handed by the United States Supreme Court in 1954, exactly 70 years ago this month. That's a long time ago, and so it warrants us asking the question, why are we still talking about it 70 years later? One answer to that question is that of all of the decisions decided by the United States Supreme Court across its history, Brown is considered by many people to be its most moral decision. And uncontestably, it represents a watershed moment in the long struggle for racial equality in our nation's history. But also, let's be clear, it took a long time for the United States Supreme Court to get to the point where it would deliver the opinion that it did in Brown, finally reversing a horror of a decision that the Supreme Court handed down in 1896, the case of Plessy against Ferguson, which established the shameful separate but equal doctrine, a doctrine that was used for decades to justify laws and practices that policed the segregation of whites and blacks in a host of settings, including, yes, K through 12 schools, but also college campuses, trains, buses, restaurants, hotels, hospitals, libraries, public pools, water fountains, public bathrooms, barbershops, even cemeteries, and entire neighborhoods. It's sometimes forgotten that the decision in Brown versus Board of Education itself was not a single case. It was a consolidation of 5 separate lawsuits against 5 different school districts in the United States, in Kansas, South Carolina, Delaware, Virginia, and the District of Columbia. And each of those cases raised the same central question. Did laws that kept black and white children from attending public schools together violate the United States Constitution? It wasn't until 1954 that the United States Supreme Court was prepared to say that the answer to that question was yes. And one of those 5 cases touched my father's family intimately. My father's family who lived in the state of South Carolina. My father was one of the hundreds of thousands of black children in South Carolina who were banned from attending schools open only to white children. And sadly, the decision in Brown versus Board of Education in 1954 came too late to impact the educational experiences that my dad had in his home state. But years later, the decision meant that his children, my brothers and sisters and I, would have at least a handful of white classmates along with our black classmates in the schools that we attended in South Carolina. Change like that has never happened quickly in the United States. As much as we celebrate the decision in Brown today, it's worth remembering that the change that it called for was the subject of massive resistance and violence. The power of the United States Supreme Court in 1954 was not sufficient by itself to attain justice for Black Americans, which was why 10 years after that decision in 1964, the United States Congress had to reinforce the court's decision by passing the Civil Rights Act of 1964. And over the long haul, the decision was also vulnerable to being undermined by other legal, if ignoble, means, such as the phenomenon of white flight. Perhaps we'll have some opportunity to explore that longer arc of our nation's continued struggle for racial equity later this evening or at some other time. In the meantime, let us hear from our special guest who will be introduced by Carlos Marshall. Enjoy the evening.
Thank you so much, Sharon, for such a thoughtful insights on Brown versus Board. Now to introduce our speaker for this evening, Cheryl Brown Henderson, one of the three daughters of the late Reverend Oliver L. Brown, who in the fall of 1950, along with 12 other parents of Topeka, Kansas, led by attorneys for the NAACP, filed suit on behalf of their children against the local Board of Education. Their case joined with cases from Delaware, South Carolina, Virginia, Washington, D.C. on appeal to the U.S. Supreme Court on May 17, 1954, which became known as the landmark decision, Brown versus Board of Education of Topeka, Kansas. This case was legally named for Oliver L. Brown. Brown died in 1961 before knowing the impact this case would have on the nation. Cheryl is the founding president of the Brown Foundation for Educational Equity, Excellence, and Research, and owner of Brown and Associates educational consulting firm. She has an extensive background in education, business, and civic leadership, having served and chaired on various local, state, and national boards. In addition, she has 2 decades of experience in political advocacy, public policy implementation, and federal legislation development. She has received an honorary doctorate of humane letters from Washburn University and an honorary doctorate of education from the University of South Florida. In 1988, she founded the Brown Foundation. Since its establishment, the foundation has provided scholarships to more than 100 minority students, presented awards to local, state, and national leaders, established libraries for children in low-income communities, developed curriculum on Brown for educators across the country, and created traveling exhibits. In 1990, under her leadership, the foundation successfully worked with the U.S. Congress to establish the Brown v. Board of Education National Park in Topeka, which opened in May of 2004. In 2001, under her leadership, the foundation successfully worked with the U.S. Congress to establish the Brown v. Board of Education 50th Anniversary Presidential Commission. Cheryl has been invited to the White House on 7 occasions. So please help me give a warm Montgomery County welcome to Cheryl Brown Henderson.
Good evening.
Well, Well, thank you so much for being here. It's an absolute honor and privilege to have this critical conversation and dialogue with you on such a watershed moment for the nation as well as the world. So in terms of, I really want to dig right into this and really set the table for everybody here this evening in terms of some of the details around Brown versus Board of Education, particularly in this era where we live with hypervisibility to misinformation and disinformation. You have been noted in talking about kind of the ways that the historical legacy of Brown versus Board has been skewed. So I'm wondering if you can just provide detail to us here today about Brown 101, if you will, and how the case came to be about and the various different sequencings that happened and how media played a role in that.
Absolutely. Yeah, the one thing I'll start out with, which will be evident in a moment, is we've all learned that if you don't tell your own story, somebody else will, and it won't look anything like your truth. And Brown versus the Board of Education is kind of a case study, an example of that very thing. Disinformation is something that we all use now, but it has followed us for 70 years. Years ago, and our family didn't discover this until the 80s, people have always come to us believing that Brown v. Board of Education was something my father did. That's number one. And they've come to us believing that my sister, who's now passed on, Linda, was the center of Brown v. Board of Education, neither of which is true. Brown v. Board was a collective action, and it was a movement, much like the civil rights movement. But I'd like to go clear back to 105 years earlier, when this nation witnessed its first school desegregation case, 1849, in Roberts versus the city of Boston. So this is pre-Civil War, that African Americans, recognizing the power of education, began to litigate around this issue of not having access to the same kind of quality education that white children had been afforded. So you fast forward 105 years later to May 17th, 1954, when Earl Warren announced its opinion. I go back again because most people don't look at Kansas, my home state, as a consequential place when it comes to civil rights. How many of you have ever been to Kansas? Raise your hand. Okay. Now, I have to always ask a follow-up question. Did you stop? Because a lot of people drive through my home state and they assert that they have been to Kansas. Kansas is one of those extremely consequential states when it comes to civil rights, school desegregation, those issues. But let me start with the fact that Kansas halted the westward expansion of slavery at its borders. Bleeding Kansas, John Brown, and all of the activity that happened that when Missouri tried to encroach on our state and tried to bring the institution of slavery into Kansas, it was stopped at our borders. That's number one. Secondly, Kansas is the only state in the country that has litigated 11 school desegregation cases before Brown v. Board of Education. The first school deseg case in Kansas was in 1881, Tenen versus Ottawa School Board. And on our website, brownvboard.org, all of those early cases have been scanned into our website. So if you're curious about those 11 cases, what the circumstances were, what happened, you can actually read the case transcripts. The interesting thing about Kansas, the legislature at the time, they passed legislation that said cities of 15,000 or larger could have segregated schools, but only at the elementary level. So when Brown was being organized, ending up in the Supreme Court, we were only talking about 3 cities in the whole state: Wichita, Kansas City, and Topeka. Many of those early cases were successful because they were brought from cities that were fewer than 15,000. Now, I'm not saying any of this made sense, because a lot of what we've witnessed in terms of denial of opportunity and segregation and discrimination and all these behaviors, they don't make sense. So I'm not saying it makes sense, But this is how the Kansas legislature decided to deal with the issue of public education. So 3 of those early cases were in Topeka. So there were 3 cases against the Topeka Board of Education before Brown v. Board. So I just want you to get the lay of the land. So for us living in Kansas, this was nothing new. So when people scratch their heads as to why on earth is Topeka, Kansas on the end of Brown v. Board, it is because Kansas has been consequential and very progressive, well, it used to be, leading up to that era. We used to export a socialist paper out of Garnett, Kansas. You know, so many things have changed over the years. And finally, Kansas was a state that actually sent emissaries to the South after the Civil War to recruit African Americans, formerly enslaved people, to come live in Kansas, promising homesteading and certain freedoms that they were still not being afforded post-Civil War in the South. So I'm telling you all this to lead up to what happened in Topeka with Brown v. Board. So now you've got the history lesson, and now you'll stop in Kansas, won't you? So Brown v. Board, Topeka. In 1948, on the heels of the 11th case in Kansas, McKinley Burnett, who was the president of the Topeka NAACP, made a decision. He calculated, strategized. We're going to try this one more time. This time we're going to go to federal court. We're not going to stop in state Supreme Court. But we need plaintiffs. So together with the 3 attorneys for the NAACP, Charles Scott, his brother John Scott, their partner Charles Bledsoe, they decided they would have a big recruitment campaign. So Mr. Burnett began by simply going to every school board meeting, trying to convince the Board of Education to just integrate their elementary schools. It was a choice. It was not a requirement in the state. You were permitted, not required. Not luck, no luck after 2 years of doing that. So he warned them that they had had 2 years to prepare for what's coming. So in the summer of 1950, the legal team that I mentioned, together with the secretary, Lucinda Todd, spread out across the city of Topeka, going to churches, talking to friends, talking to family members who are African American, people that had children in elementary school, because remember, we're talking elementary schools. Junior highs and high schools were integrated. My mother went to integrated junior high and high school, and she talks about how academics were integrated all day long. Students were in class together. But when it came to prom, when it came to extracurricular activities, there were even 2 basketball teams, 2 cheerleading squads. So again, none of this made sense, but this is how Topeka handled the issue, the social issue of integration. So when this didn't happen, Mr. Burnett, his team spread out across town. One of them came to our home. So literally, history knocked on our door. So Charles Scott, my dad's friend, who was one of the attorneys, asked my father, called on friendship, if he would be willing to be a plaintiff in well, it wasn't Brown v. Board, a plaintiff in the case they were organizing. We do believe that it may have been all women, because when they came to our home, there were 9 people who had already signed on, 9 women, married women who were homemakers. So for my father, it was kind of are you going to recruit any more dads? And he was concerned about perhaps ended up being the only dad. I jokingly say that my mother in our family would likely have stepped up to be a plaintiff, but she was expecting, and her favorite child had to get here. So she could not do that because at the time pregnant women didn't go out and about so much. So long story short, in the fall of 1950, they had assembled a group of 13 parents representing 19 children who were the plaintiffs in Brown v. Board of Education. The parents were the plaintiffs on behalf of their children. So much to my dad's chagrin, he was the only dad. So when the case was filed in February 1958, or 51, excuse me, February 28, 1951, it was then called Oliver L. Brown et al., meaning and others, versus the Board of Education of Topeka, Kansas. People ask us, and have really engaged in conjecture that perhaps it was named for Oliver Brown because of the alphabet. No. It was named for Oliver Brown because of his gender. When you look at the roster of litigants on our website, you will see that Darlene Brown, equal in every way in terms of being a plaintiff, but alphabetically first. D comes before O. But he was the only man. And we figure gender politics of the late 40s and early 1950s, somebody, either as a legal strategy or the clerk of the court, we really don't know why it ended up being named for him, except for gender. And we don't know in what way gender played a role. If it was strategic, if it was simply, back in the day when men used to be really important. Either one of those things, we're not sure which. But it ended up being named for him. So maybe it wasn't such a short story, but that's how it ended up being organized in Topeka and ended up being named for my father.
Absolutely. Thank you so much for sharing such an exhaustive background. And as you alluded to, history knocking on your door steps, literally. I'm wondering if you could just talk a little bit more. What was the specific motivation behind your father and your mother presumably agreeing to just become, at that time, just one of the many other plaintiffs that were already on the case, other than your father's friendship with one of the lawyers?
Yeah, that's a good question, because you figure in that era, anytime you took a public stand against Jim Crow, you were taking a risk. Not perhaps so much in Kansas, but definitely across the South. The other thing I'll say in Topeka, we lived in integrated neighborhoods. So Kansas did make good on recruiting African Americans into the state, and there was a certain level of equality. So our neighborhoods were integrated, but the odd thing about that was our white neighbors living right next door, kids played together all evening, all summer, but in the morning when the school bell rang, my sisters went one way, and their white friends living next door went another way. So it wasn't a matter of not always already associating. Workplaces were integrated. The only vestiges of Jim Crow were department stores and some restaurants. But that's, how it was, how we lived in Topeka. It was, it was kind of a contradictory, ambivalent situation. So my mother, who is now 103 and very healthy 103-year-old, thank you. I'll tell her you applauded. And she, I just came back from Kansas about a week ago, and we laugh about the fact that that is one woman. If you want to go someplace and you're thinking it might not be easier for her to go, don't say it in front of her, because she'll want to go, and she will go. So I love that she's so healthy at 103. So she's persuasive. And my father was studying for the ministry. He became an African Methodist Episcopal pastor in 1953, the year before Brown was decided. But he was studying, working all day as a welder for the Santa Fe Railroad in the shops. My parents had owned a restaurant together with my mother's cousins, and it was called Cousins. How creative. And so they shut down the restaurant so he could work all day and then go to Washburn in the evenings in preparation for becoming a pastor. So she had to persuade him, because he looked at this as, one more thing. My plate is full. But her argument was, you're stepping out to be a leader. Ministers are considered leaders in their community. You're going to be leading a congregation. This is something you should do, not just for our children, but for our community. So that's really, her persuasion is what convinced him to go ahead and sign on.
Thank you so much. And you've also talked about the number of other cases that preceded Brown versus Board, even in the geographical region of where that was initially filed. But also last year it was surfacing in the news, as well as it continues to surface this year as well with the 70th anniversary, about Briggs v. Elliott, really putting in a request to the Supreme Court to rename Brown versus Board of Education Briggs v. Elliott. So if you could just kind of elaborate on why that is, and ultimately what was the distinction of Brown versus Board of Education versus the other numerous cases that came forward that allowed it to proceed and ultimately be awarded?
Let me start out by saying that Nathaniel Briggs and I are friends. And when contacted by the media, my response was, I understand, what they're trying to do, and I understand why they're trying to do it. So you're not going to get into argument for me. The media courts controversy. And there was no controversy to be had. I mean, this is a man I've known for decades, and I understood. We had to respond, however, so I won't say that even in my being civil, we were certainly going to push back. So our attorneys did also petition the Supreme Court to not take it, up in a serious way, and they did not. Now if I'm giving you the backstory really quickly, we discovered over the holiday that it had made its way to the United States Supreme Court. So our attorneys had to get very busy and scramble and get our petition sent to the court by January the 3rd, 4th. Because on the first Friday of every year, the court meets to determine which appeals they're going to actually take up. So we had to be there in time for that conference, as they call it. So when they did look at the writ of mandamus submitted by the Briggs litigants, ours would be there to counter. So in all honesty, what the Briggs litigants were after, when cases are appealed to the Supreme Court, there's always one that gets there first. So the school desegregation cases appealed to the Supreme Court. Briggs versus Elliott arrived first on appeal. Briggs versus Elliott then was set back on a technicality. It was remanded to the lower court. So they had to get something cleaned up, cleared up, changed. I don't know if it was verbiage. I don't know the details. So while it was back in the lower court, along comes Brown v. Board of Education. So by the time Briggs comes back to the court, Brown v. Board is now at the top of the docket. So in their way of thinking, that historically, perhaps writ of mandamus is a legal phrase for correcting a legal error. So in their way of thinking, this petition would get the court to consider the fact that was it in error, instead of waiting for Briggs to come back to then allow Brown v. Board to be first in line. It's just that simple, very rudimentary in terms of what they were hoping would happen. In their writ, however, they also talked about the hardships. Briggs v. Elliott is South Carolina, and South Carolina and Kansas are apples and oranges. So they talked about the burning of homes, the Reverend Delane's church burn, Mr. Harry Briggs Sr. run out of town. He had to leave to find work in Florida, people being fired from their jobs. It was believed one gentleman was actually murdered because the Stooks family found him dead beneath a car. He was an auto mechanic, and somebody had kicked the jack, they believe, and it had fell on him. So a lot of really unseemly hardships. All of that was within the writ. Kansas, on the other hand, gave the court a unique opportunity, which is why we think the court never entertained putting Briggs first in line once it came back to the court. There was a book by Juan Williams, who's a journalist, and the book is called Thurgood Marshall, American Revolutionary. It's probably maybe out of print, but Amazon has everything. So you can probably, and I would advise reading this book. It's an amazing book about Thurgood Marshall's life. But in talking about Brown v. Board, Thurgood Marshall actually says that Brown v. Board gave them the best test of segregation per se, because the schools were found to be equal. The quality of education was stellar, in that African American teachers in Topeka held more advanced degrees than their white counterparts in those elementary schools. Transportation was provided. So all things being equal, this gave them a chance to rule on whether or not it was constitutional to segregate based on race. Because we couldn't assert we were pursuing matters of inequality. then it became really a humanitarian issue of if race is the issue you're using to separate people, when the 14th Amendment, those three Reconstruction Amendments are in place, is that legal? So in his book, he talks about that. And so our petition to the court made that clear. Remember that the court used Brown as a way to rule on the principal issue, with all things being equal, that segregation was in fact unconstitutional based on race. So there was a legal reason to allow Brown to stand as the first case. But I certainly did understand what they were trying to do, and no hardship. I was just with him a week or two ago. We were all at the White House and had some programming in DC, and would never leave him out. But I tell you one thing, it's certainly not a conversation we've had, but I do understand.
Absolutely. Thank you for that. And also, with the historical context that you provided of why that particular case was successful and why it was on the docket, help us understand about what took place in Topeka, Kansas, following the court ruling. What was that like from the recollection of you, your families, as well as just the historical record of what happened thereafter?
Mm-hmm. I hate to paint such a rosy picture of Kansas, because although you may want to stop, but the one thing that concerned my father when he was interviewed, post Brown v. Board in the days following, was what would happen to the African American teachers. He was really concerned about that, because in the spring of 1953, divide and conquer, the superintendent of Topeka Public Schools sent a letter to African American teachers that were not tenured, meaning 3 years or fewer teaching in Topeka Public Schools. We have a copy of that letter, and the letter basically said that if the plaintiffs succeed, we will not renew your contracts. It goes on to say, we will not renew your contracts because we do not believe there'll be work for you. We do not believe there'll be enough white parents willing to have their children taught by you for us to renew your contracts. So on May 17, 1954, when Earl Warren announced to the country the unanimous decision, Topeka Public Schools made good on that promise, and those teachers' contracts were not renewed. So the other thing this brings up that people have to understand is the African American community was no more monolithic then than it is now. So there were people in the community that did not want this to happen. The 4 African American schools, McKinley, Buchanan, Washington, and Monroe, were the pillars of the African American community. Beautiful brick buildings, excellent teachers that were well respected. It was a state congress of parents, colored parents and teachers that would meet in Topeka. They didn't see the reason. Students coming out of those schools were ready to compete with anyone. They were worried. The issue was bigger. And in looking at the big picture, and I give young people the example, although I've got to come up with a better example, if anybody has one. There used to be a television show called Under the Dome. It was Stephen King, I think, and it was that people lived under this dome. The example I would give them, okay, if African Americans living under the dome, but when you open the door of that dome and step out, your rights were abridged, you couldn't eat in restaurants, you couldn't try on clothing, your life could be threatened. You couldn't live your entire life under the dome. So the bigger picture was Brown v. Board. Schools were the battlefront, but society at large was, in fact, the target. So in terms of pushback in Topeka, the letters that went out the year before, one of the plaintiffs asserted there was a group of young white men that circled her block once, but there wasn't any pushback. And I think because people were already living around one another, already socially associating. So we didn't have the same issues of South Carolina and Virginia and Little Rock in Topeka. So I started school that next fall, in the fall of 1955. but my sister Terry, our middle sister, is the only one in our family that started school in an integrated setting. So it's been an interesting experience. And, you know, I compare my mom and sister's experience to my own because going to their reunions, it was like a big family reunion. The teachers would be there, even the truant officer, which is something people don't have anymore. Everybody was there, and it was just so, all the camaraderie and the goodwill. And then I started that next year, 1955, kindergarten through graduate school, never had a teacher of color. My experience was quite different. The example I give is the lessons I learned were perhaps not so much the lessons of uplift, you know, that was taught daily in the segregated schools. The lesson I learned was that education is a very intimate process, meaning it's 100% on you. Teachers can guide, they can encourage, they can direct, but becoming an educated person depends on you. So being in school, kindergarten through graduate school, never having a teacher of color, always having white teachers, some that made it clear that they were not entirely pleased with my presence, some that had absolutely no expectations for me, you know, was an amazing lesson for me to understand that if I was going to do this thing of education, then it was up to me. So very different lessons than my mothers and sisters had. But 38,000 African-American teachers across the South lost their job. So not only did the Topeka superintendent send out letters of threat, it happened in real time, you know, by the thousands across the South as schools integrated. But we didn't have that kind of pushback in terms of any violence or in Topeka.
Absolutely. Thanks so much for sharing, and want to dig in deeper here in a second to your own personal journey. But as you're talking about the social integration of the local level in Topeka as well as other places nationally, I'm wondering if you could talk about how Brown v. Board also set a precedent for a number of other Supreme Court decisions, such as the 1964 Civil Rights Act, 1965 Voting Rights Act, and then 1968 the Housing Rights Act. As you have been noted in saying, and I quote, "Ironically, Brown versus Board holds more resonance in other sectors of society. For example, every time a person of color checks into a hotel or is served at a restaurant. However, the Brown decision does not resonate as resoundingly in public education, where it was intended to have its greatest impact."
The internet. Once you quote it, it's out there. So you're absolutely right, and I do believe that. I believe it because in the wake of Brown v. Board, the pushback started rather immediately, and it hasn't stopped to this day. The pushback coming from Congress, let me give you that example. Nearly 100 elected officials in Congress wrote a document called the Doctrine of Constitutional Principles, but colloquially known as the Southern Manifesto. Worth reading online, believe me. Basically, they said that as congressional reps, House and Senate, they were going to do everything in their power to overturn, reverse the court's decision. They went on to make it clear that any school district in their district across the South planning to defy the court's decision, don't worry, we have your back. The state of Virginia, you know, led by the governor, reinforced by his congressional reps in the House and the Senate, instituted a plan of vouchers, sound familiar? So that white parents would have a way to ensure their children did not have to go to school with African American children. He went on to penalize school districts in Virginia that were planning to comply with the court's decision. So this pushback was rather immediate, very technical, coming from the top, and not just the state of Virginia, but they led the massive resistance. So a lot of what we see now, I think, is just a continuation of what they started and ways around things. Making sure, I know Brown 3, I don't know if you're aware that was a Brown 3. The Brown 1 was Earl Warren's pronouncement of the unanimous decision in '54. Brown 2 was May of 1955, when the court reconvened to give the country its direction for implementation with all deliberate speed. And I'm sure everybody out there, if you know what the word deliberate means, it means slow. And not just normal slow, we're talking painstakingly slow, which perhaps there was a message embedded in that. And then Brown 3 was something that happened again only in Topeka in the mid-1970s. But the whole point of this is people who wanted to defy the court's decision have not stopped. I've learned, by watching all of this, that Supreme Court decisions are just the beginning of a conversation. Those that win are happy, excited, talking about victory and implementation. Those that lose are busy strategizing to obstruct, overturn at all cost. And if you go back and look at Supreme Court decisions, you'll see that is in fact the case. Brown was no different. So the conversation on the losing side has led us to a lot of what we see today. I think it was on MSNBC on the 18th that evening, and the gentleman that was the host talked about a group of white citizens in Louisiana that were trying to secede from New Orleans so they could have their own school district as well. That would be, in fact, white children only. So this is not stopped. And what saddens me about what I see in Florida and Oklahoma and Mississippi and it's merging in Kansas and other places is if you deny children the opportunity to learn about the experiences of other people, how on earth are they going to develop empathy? So will we have an entire generation that will be even more me-focused than they are now? I mean, it's a frightening thought. The governor of Mississippi stepped to the mic, talked about how she was looking to replicate what the state of Florida was doing. Then she went on and said, in this state, we are not going to support the teaching of divisive concepts. I am not a divisive concept. The history of people of color in this country is not a divisive concept, but the buzzword she used was what my mother used to call nice nasty. When you're saying something nice, but within that phrase is a whole lot of nasty. So to suggest that teaching about people that were born LGBTQ or people that are people of color are divisive concepts. So we need to be very vigilant about what started right after Brown and what hasn't stopped since then.
Thank you so much for that. Just so much that we're seeing still just the current unpacking of an impact and the fight continues. So we appreciate you continuing to fight the good fight. And you talked about after the Brown versus Board Supreme Court decision that you then went to school that following school year. So with this all occurring as being such a young person, how did you, with your own personal journey, how did you come to be aware of your family's involvement in this?
That's a good question. Well, awareness takes a certain level of maturity. So it wasn't until probably my late 20s, even early 30s, that I became mature enough to really want to understand better. My father died in 1961. I think you heard that in the bio. He died suddenly, 42 years old, and I was 10. So at 10 years old, you certainly don't have an interest, understanding, or even awareness of that being our surname, on a Supreme Court decision. My sister Linda was 18. My sister Terry was 14. My mom was a quintessential 1950s homemaker. So we're talking about a woman who now had 3 girls and was without her spouse. So Brown v. Board was never talked about in our home. It was not dinner table conversation. It wasn't top of mind, as they say now. So it really took my finishing college and grad school, and at that point I'd become a state educational administrator and was doing OCR reviews about issues of disability at the time. But that also led me to the civil rights impact of Brown v. Board and starting to research and learn. That's how I discovered the 11 cases that were in the annals of the Kansas Supreme Court Library. So it took some time. Now the one glimmer I had, although it didn't register, when my father died, we were living in Missouri. He was at his second church at the time, Benton Avenue AME Church in Springfield, Missouri. So Mother moved us all back to Topeka in with her parents. And so one day I'm coming home from junior high school. This is 1964, the 10th anniversary of Brown v. Board. So as I get closer to the house, there's a white man standing on the porch. Now, the white folks lived in our neighborhood, but it wasn't a white man I recognized. So I was sort of reticent, in coming close to him. So he stuck out his hand and he said, "Hi, my name is Charles Kuralt, and I'm here with a show called On the Road with Charles Kuralt for CBS. We're doing a story about the 10th anniversary of Brown v. Board." Okay. So I said, "Nice to meet you, Mr. Kuralt." Went inside with, cameras and wires and everything. And 13 years old, you walk right past that onto my room where the door closed, the way I liked it. So I wasn't concerned about what was going on in the rest of the house. So it took that maturity to really understand, what happened, who was involved, and all of the details. But I will say this to you. The disinformation that I mentioned earlier, and the thing about not telling your own story, it wasn't until the 80s that we discovered, actually, we had a family meeting. I was explaining to the family what I believed happened. Because in 1987, Life magazine published a special issue on the Constitution. That was an aha moment. The aha moment was the realization that it was Life magazine that created the myth that Brown was all about the Brown family, that Brown was all about Linda Brown. Brown was all about Oliver Brown, her father. Because they sent a photographer to Topeka in 1953, and he took photos around town. He knew it was a class action. He saw the buildings, but somebody made an editorial decision. Because the media likes simplicity sometimes. And so the focus was all on our family when it hit the magazine. Back then, Life magazine was like Twitter, X, Facebook, Instagram, whatever else is out there. If it was in Life magazine, had to be the truth. So for 70 years, we've lived with somebody's editorial decision. And there's still textbooks in this country. There's still people that believe what Life magazine intentionally, mistakenly, or trying to make something compelling placed on our shoulders. So that's how it ended up being known the way it's known. So the work we do at the Brown Foundation is all about pushing aside that et al., any attorneys in the audience, those are scary little letters, because it relegates hundreds of people to legal wasteland. They become historic footnotes. So we were determined that would not happen to the plaintiffs in Brown. So pushing aside the et al. And talking about the Briggs plaintiffs and getting together with them several times a year. And we all go off together to these big events the plaintiffs in Delaware and Virginia and South Carolina and so on, they need to be known because their sacrifice was, as the Briggs plaintiffs would explain, much greater. Aftermath, for example, in Virginia. We know about Little Rock, Arkansas, schools being closed for a year. Most people are not aware that schools were closed for 5 years in Farmville, Virginia. They're learning now because as we have been pushing this for the last 40 years, it's starting to take some root, it's starting to get out there that Brown is all of these cases and all of these people and these things happen to them. So the example I like to give about Virginia is if you are in 3rd grade, you're 8 years old generally in 3rd grade, schools close. 5 years later, schools reopen. You're now 13. Do you go back to 3rd grade? No. So I've been to Farmville, Virginia several times. One of the things that happened, white academies, they call them segregationist academies, sprung up. Federal money funneled into those places. For African Americans, if you couldn't afford to send your child out of the county, there was no school. For whites who were not very affluent, there was no school. So there are people there to this day, now aging, that are still upset with this country, denying them 5 years of their education for no other reason. But as an example of how determined the majority population has been to hang on to power and privilege, you would go to those lengths, closing schools for 5 years. I mean, that's really something. So that to me, that's the most egregious, I think, of all the pushback.
Certainly, you talk about the closures of schools. Previously, you stated about the tens of thousands of African-American teachers that lost their job. You also alluded to the fact with Topeka, Kansas being, to a certain degree, socially integrated at a time that there were also folks that, black families that were not concerned with integrated and desegregated schools. So I'm wondering if you could speak to what is the current status of academic achievement of black students in Topeka, Kansas, and do you believe in what would you say to somebody that would argue that desegregation adversely impacted black children?
Yeah, first of all, I agree because I think no one anticipated, these are unanticipated consequences of Brown, and there were many. And no one anticipated, the nature of the pushback. So when you look at public education and the rhetoric that is now emerging, failing underfunded public schools, which is totally insane when you collectively consider the resources available to the public. My response is the focus still has to be education with a capital E. Teachers need to educate, and I'm sure they feel this way, the children that show up. Let's let the policy makers worry about counting heads. There's no reason why, if I'm a student in a school predominated by students of color, that it still should be a world-class experience. There's no reason, none. If I'm in a school that's predominated by Latina students, it should still be a world-class institution. We oftentimes fall prey to propaganda, and we don't get into the weeds of what's really being said. Propaganda is one of the most powerful tools of any government at any level. More powerful than anything. If you can convince people of something, you have power over them. So my position on this is, first of all, Earl Warren read the wrong part of the opinion, in my view. The opinion is 14 pages long, not this few sentences of in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. And then it went on to say that segregating African American children under the weight of law creates a badge of inferiority in ways never to be undone. I don't agree with any of that. The other part of the opinion that comes before that statement is this. He says, the court said, education is the most important act of state and local governments. No child can be expected to succeed in life without the benefit of an education. And where it is provided is a right, they use the word right, that must be made available to all on equal terms. The significance of education is what he should have started with, in my view. Because when he talked about the separation, the inequality in separate facilities, he used the word inferior. You know, segregationists were probably, partying, because that gave them a focus. Now, we can make sure we fight to keep these things separate. We want to make sure we fight to assign this badge of inferiority, which is not a word you use with people. It's a retail word. Inferior products, not people. There's no way people can be inferior, because I don't care who you are, we all got here the same way. We were all born. There's no exception. So there's no such thing as anybody better than anybody else, unless you came here from another planet that we don't know about. But it's just ludicrous to think that our beginnings are 100% the same in terms of our emergence. But it's all of the propaganda and mistreatment that happens once we're here that creates that sense of some being more privileged than others. So I really wish he had started out with that, with the significance of education, so that we could get back to what we're supposed to be doing, which is educating, so that we can have an informed citizenry, so that people can have the ability to achieve to the best of their ability, without obstruction, because a lot of this is artificial barriers. It is intentional that there are schools that are failing and underfunded, but we're asking the wrong questions, I think. So I subscribe to the notion that it doesn't matter who's in the classroom as long as education is taking place there.
Thank you so much for that. And talking about people wielding political propaganda, I think there's a lot of concern around the country in terms of the regression of equal rights. And when you talk about the opinions of coming down from the courts, language absolutely matters. And you talked previously about the Southern Manifesto, in which congressmen from the South said that they would do everything in their power to repeal that decision. Many believe that we're now seeing the fruits of their labor with the repeal of affirmative action, Roe v. Wade.
100,
And so when we're talking about shaping language and discourse through media, as well as the language of the Supreme Court, I want to ask you specifically about something that Clarence Thomas is recently noted in saying, because the Southern Manifesto really was indicating that there was a judicial overreach. And now Clarence Thomas is noted in saying that that Supreme Court decision of Brown v. Board had a boundless view of equitable remedies. And he said that federal courts do not have, and I quote, the flexible power to invent whatever new remedies may seem useful at the time, end quote. So with that being said, is there any fear from you and the other families that Brown v. Board is in any way in harm of being repealed in any time in the near future or our lifetimes. For
No,
that
that's an
matter.
excellent question. We've had those conversations about, are we next for the chopping block? And I find it interesting that Justice Thomas would steer clear of Loving v. Virginia when it was advantageous for him. He could marry someone that considered to be of another race. So I find it concerning because with this particular court, and his statement illustrates that, and some of the flag upside down thing that we've been hearing about illustrates that it's hard to separate the person from their agenda. It's hard to separate the person from their biases. And we'd like to think that the law is a shield against injustice. People of color know that the law has been used to perpetrate injustice. So it's troubling to me when it seems so obvious that he is speaking to those from whom he has been able to engender, not that's the wrong word, but to benefit. And it's troubling to me that a person of color who was put on the Supreme Court basically to replace Thurgood Marshall would speak in that manner. Because if nothing more, having respect for Justice Marshall and the legacy he left that you were then, upon his death, being confirmed to replace. So you have to ask yourself, and I'm beginning to think that we need to have, within the vetting, there needs to be psychoanalysis. And let's not just vet looking at their tax records, but we need to get up here and make sure that they're going to be the kind of thinkers, they're going to be the kind of people that will respect the rule of law and have fidelity to the law and not be caught up in their own agendas, because I'm afraid that we are seeing law decision being dispensed by people with chips on their shoulder. Not only is it not a good look, it's detrimental to the country. I would encourage all of you, and I've done it a few times, you can go to the United States Supreme Court website, go down the list of any case, click on that, and you can listen to the oral arguments. I listened to the UNC argument months ago, and Justice Ketanji Brown Jackson was new to the court at the time. But what was so stellar about her being there as a new person, and sometimes when you're new, you think, okay, I'm going to not only show them what I know, but I'm going to speak up. I'm going to be that kind of justice, a full participant on the court. I'm listening to this argument. She called them when one of them, who shall remain nameless, asserted that the Constitution was not a race-conscious document. Her pushback was, wait a minute, 13th, 14th, and 15th Amendments to the Constitution were all about race. So we cannot sit here on this bench asserting that the Constitution is not a race-conscious document, since we're arguing a race-conscious case. Then she went on to say, what you're asking in UNC, let's say her example was, I'm a black child in North Carolina. Generations of my family since slavery have been here. I've always wanted to go to UNC, but now you're telling me I cannot write this down that I'm an African-American person with, or even leaving that out, just saying that generations of my family have been here since, starting with enslavement. I've always wanted to somehow identify that I'm a person of color. I'm supposed to deny myself. I'm supposed to somehow step out of my skin, my experiences, my culture, my beliefs, deny my family in order to be accepted by UNC. Because you're saying that they cannot consider my experiences and my race. So do listen, by the way. I'm encouraging you to do that. It is worth listening. But what also strikes me is when you think about that kind of argument, and you think about DeSantis in Florida, and you think about the woman down in Mississippi, the governor, and you think about the people in all these different states. To me, they are on a campaign to codify white supremacy. Because if you cannot learn about anyone else, if you cannot speak the word segregation, if you cannot speak the word discrimination, if you cannot speak the words based on race, what else could the mission be? In Florida, DeSantis is permitting or authorized the use of these 5-minute videos from Dennis Prager, his online Prager University, which is not a university at all. He's a right-wing radio talk show host. Prager University. And he's developed these 5-minute videos. I looked at a few, and then I needed some Pepto. Sickening. Every one of them ends with the message of the benevolence of the majority population. You tell me that's not an attempt to codify white supremacy, so that everybody, regardless of ethnicity or gender or race, will believe it. He actually said, yes, this is indoctrination, but indoctrinating children with the right thing. When he has one video that talks about Frederick Douglass agreeing with slavery as an acceptable compromise, I would encourage you to look at them, as many as you can tolerate. It's just shocking to me that, we would, first of all, market them to school districts, and I'm sure Florida is not the only state that has agreed this could be shown in a classroom. But it is it's not even revisionist history, it's just straight up lying. Let's call it what it is. But those are the kinds of challenges we now see. So it's no longer being blatant about keeping children of color out of spaces where they want only white children to be. But it's also about trying to then indoctrinate them into believing, that perhaps they are inferior. Because we've got these little videos over here that show the only benevolent people, the only ones that have done anything, the only ones that saved the day, don't look like you. So, there's a lot to be concerned about, in the scheme of things, because the kind of focus groups these people put together, I'm not sure I'd even want to be a fly on the wall to hear these conversations. Because who comes up with this? Who is so evil to push that kind of agenda on the country? So we have a lot to worry about come November. I mean, nothing small. We're talking major, cataclysmic stuff to worry about.
Thank you so much for that, and want to personally thank you and send gratitude for you to continue fighting the fight on behalf and amongst all of us. The work of your father, your mother, your entire family, all of the families that were part of that case, we truly do stand on y'all's shoulders. And so with that said, as you mentioned before, your father was not able to see the impacts of that decision. So now being just 13 days removed from marking 70 years, if he was here today, what do you think he would have to say?
Well, I think he would agree with me that being a United States citizen is not a spectator sport. It is not. You know, you really have to step up and be engaged. You know, I used to chair a women's organization where we would read legislation. And it taught me something that my father would agree with, that you cannot take the word of the person that you voted for. You need to get into the weeds and find out if what they are saying, you know, is in fact what this bill contains. You know, what they are saying will in fact have the impact, an impact that will make your life better. We would read legislation that wouldn't resemble the buzzwords. President, example, H.W. Bush would always come out and talk about the Civil Rights Restoration Act. And he would talk about, he didn't want to sign a quota bill. Well, when we read it, it was a bill about women in the workplace mainly. Certain level of remuneration. Created the Glass Ceiling Commission. It was not a quota bill. The word quota wasn't even in the margins. But unless you read it or asked questions, you would support the fact, you know, black folks didn't want to be considered quotas. The little focus groups that they'd put together of blue-collar white men, and they asked the question, what pushes your button when it comes to civil rights? Quotas, which gave him the buzzword to use. Now, there's so many things that happen with politics at every level that it behooves you to have a greater understanding of. There's nothing that prohibits you from going to school board meetings. There's nothing that keeps you from going to city council meetings. There's nothing that keeps you from, you know, reading federal legislation. What people count on in power is that you won't. We need to prove them wrong. Thank you.
Thank you.